Welcome to the Disability Approval Path.
Hello and welcome back to Social Security and Disability, the Approval Path with Deborah Spector, lead attorney and managing partner at Spector & Lenz. With over 40 years of experience, Deborah helps clients navigate the rules and maximize their benefits. I'm Chelsea Reynolds, and today we're talking about workers' compensation and social security disability. Can you get both? Will one reduce the other? Let's break it down. Episode 5, Workers' Compensation and Social Security, how they work together and sometimes don't. So Deborah, hey, welcome back.
Hey, Chelsea, glad to be back. And I have to tell you, I think I'm going into like my 47th or 48th year of doing this. It's like forever. And it took me about 42 to be able to pronounce Social Security.
This is going to be a long episode if I can't say it, but hey.
Don't worry. Glad to be back and glad to talk about these topics. They don't affect a lot of people, the work comp, Social Security interplay, but when they do, it can be devastating, and it's very important to plan properly for them.
Let's dive right in. What does workers' compensation cover versus Social Security disability?
Okay, first of all, Social Security, as I've explained in previous podcasts, is nothing but a gigantic insurance plan run by the federal government. And if we're lucky, it's there for us in retirement. If we're not, it's there for our kids and certain other dependents in premature death. And it's all, and sometimes for certain recipients, even as they're adults. But for disabled workers, it's a long-term disability plan, just like Unum or Prudential or anything else, but run by the federal government. And it kicks in when a worker who is paid into the program sufficient number of, we measure it in quarters over his or her working lifetime becomes disabled. And the definition of disability is worth 7 of our sessions. So I'll skip that right now. Workers' compensation is different. Workers' compensation is a program run by the states individually. Now, I'm in Illinois. It's run through the Illinois Industrial Commission. It's a creature of state law. And workers' compensation is available if we get hurt on the job. And without going too far into the weeds, the employer has to pay into a fund or carry insurance and whatever. But it's private money that is then paid out to a disabled worker, not government money, on the an injured worker. It doesn't have to be a disabled worker. An injured worker on the occasion of an injury causing lost time medical expenses that occurred in conjunction with the job. So state, federal, permanent disability, any injury. Now, can a worker collect both? Under some circumstances, but the important thing to remember is that they're both, in theory, income replacement programs for workers who cannot carry out their normal duties, either for a short period of time or permanently, workers' comp, or at least for a year, Social Security disability. So that's a basic difference.
And Social Security doesn't have to do with age or anything, the disability?
Well, of course, it's only available to people under full retirement age.
Okay.
With one exception, and that is lawful permanent residents who are over retirement age do have to prove that they're disabled to collect certain kinds of SSI welfare benefits. But no, the definition of disability involves age. So the question of whether a person's disabled factors in her medical condition, her past work history, her skill level, her education, and her age. Because the issue is there work out there in the national economy? Age is really important there. Workers' comp is quite a bit different because the injuries, we call them scheduled, and they're scheduled. Certain injuries are worth so much money, so many weeks of pay. You know, it's a different kind of analysis. And they're not the same. And just like with unemployment comp, the definitions of disability vary from program to program.
Is it possible for someone to receive both workers' comp and Social Security disability at the same time?
Well, sure. And here's where we run into the kind of the arcana and the technical problems in this field. If a worker is injured and we know he's going to be disabled for more than a year, then that worker should generally apply for Social Security disability insurance, get that ball rolling. It can take a long time to go through the appeals and get that thing approved. In the meantime, the worker files a claim, notice to the employer, files a claim with the Industrial Commission, may, if he's lucky, begin receiving temporary cash benefits from the employer or the employer's insurance company while the Social Security case is cooking a lot, right? So ideally, a seriously injured worker will have both programs running at the same time. Now, if he gets temporary benefits until his case is finally resolved at workers' comp, either by settlement or by a commission order, then that worker may see his Social Security benefits, if they're approved, reduced somewhat because of the receipt of workers' comp. Again, the theory is these are both income replacement programs, right? And so the theory is generally that your combined Social Security and workers' comp payments, and we usually look at them monthly, should not exceed 80% of your average current earnings. There are a few formulas for what average current earnings mean, but generally I tell people, look at the 5 years before you became disabled, and it's the highest year, divide by 12, 80%. That's your average current. It's kind of your net, what you used to net in a good year, and your combined Social Security and workers' comp can't exceed that amount because they're both income replacement programs, and the programs are set up so that you don't have a windfall. You don't end up with more income on disability and comp than you used to receive while you were working. So that's kind of the general theory for how they're offset. Now, in our state, Illinois, and in most states, if you're receiving both workers' comp and Social Security, the formula is applied and the Social Security could be reduced. It's called an offset. It can be reduced if your workers' comp is high enough until the case is settled or otherwise resolved. In some states, about a dozen, the opposite occurs. And it's the work comp that's reduced because you get Social Security. But let's not talk about those states.
Are the rules different depending on whether you're receiving SSDI or SSI?
Well, sure. I mean, this really generally only happens in SSDI. And for a couple of very basic reasons. But the first is that SSI is a welfare program run by Social Security through Social Security. It covers the elderly, the blind, and the disabled, but only a very low income, very low assets. So if your income exceeds a certain amount, you don't get any SSI, even if you are disabled. Well, look at the program we just looked at. If you're getting what we call TTD or something, temporary total disability, or you settled a work comp case and you have a boatload of money in the bank, you're not going to be eligible for SSI anyway. So we're really looking at SSDI claims. And again, the DI is the important part, disability, and the I is insurance because it's an insurance program.
Okay. What kind of paperwork does Social Security need in order to calculate this offset properly?
All right, bane of my existence, okay? Let me go down a little alley. You know, in my state, workers' comp cases, properly developed, righteous cases, eventually settle. And when they settle, the worker and the employer, we call the respondent, the defendant, the respondent, enter into an agreement under which the worker often receives a lump sum of money. It can be paid in annuity, it can be paid in a lump sum, whatever, with a million different situations that can arise out of that, but gets a lump sum of money rather than a periodic payment, right?
Mm-hmm.
SSA wants to see that settlement agreement, number one. Number two, SSA wants to see a printout of what was paid to the worker while he or she was receiving the temporary benefits. Because SSA then goes month by month. Okay, June 2024, did you get $2,000 in TTD? They'll use that to figure out the adjustment in the Social Security benefit that's owed for that month. Those are kind of hard to get sometimes. They're not hard to get, but there's a delay because we have to work through the workers' compensation lawyer. Our firm doesn't handle workers' comp. We have to go through that lawyer, have that lawyer go to the respondent's lawyer, have that lawyer go to the insurance company and get us a printout. So it can take a minute to get the documentation, but SSA does require documentation.
This is a lot of different moving pieces. Yeah. If you're working on a settlement, can a settlement agreement be structured in a way that minimizes any sort of offset?
So look, of all the stuff we're talking about, Chelsea, much of which makes no sense, right? The most important part is this part. When a person settles a case, there's a net amount to the injured worker. Okay, so you have a gross settlement, and from that you deduct attorney's fees, medical expenses, costs of whatever. Also, often there's something called Medicare set-aside, which means some of the money's peeled off the top, goes into a special account. So if there is medical attention required for something arising out of the work-related injury, Medicare doesn't want to pay for it. So the worker sets some cash aside to pay for it. We get down to a net amount to the client, to the worker. And in the commission, he's called the petitioner. That amount is the amount that Social Security is going to look at to see if we're exceeding that 80% figure. And they do it by prorating that amount over time. Well, what a worker can, should, and properly must do is have the workers' compensation lawyer, again, I'm speaking Illinois, take that amount and do the proration herself. So what the language typically looks like is something like, Chelsea's going to get $300,000. The net to her is going to be $200,000. She is, 46 years old, and prorating that's worth $200 a week. Well, what we just done, we brought down the figure that we put into the formula to figure out the offset. This special language is called spread language. It is the goofiest thing in the world. It is absolutely magic. It seems like a fiction. It seems like, it works. And the Social Security rules, which are founded, actually anticipate it and give us how it's written properly. So yes, the settlement contract in workers' comp has to be written in a way that minimizes the offset. Let me mention one other thing before I forget. And I warn clients about this when I take them. If there is an offset, and it won't happen until way down the road when we're successful in the Social Security claim, but if there is an offset, and a guy's entitled to, let's say, $3,000 a month in benefits, but is only going to receive $1,000, that $2,000 that never goes into his bank account might be taxable. And I just give clients a heads up. I don't offer tax advice. We don't prepare taxes or give consultation. We are definitely not tax lawyers. But I always give clients a heads up. Go find one when the time comes, or be prepared. You may have a little tax bite at the other end. So that's the important thing about this subject is making sure that the language in the workers' comp settlement contract is drafted properly to minimize the effect of the workers' comp offset.
You've mentioned Illinois a few times throughout this episode. Are there any Illinois-specific factors or Illinois-specific timelines that people need to know about?
No, not that I'm aware of. But again, I don't practice workers' comp. I practice Social Security, and I do want to give you a quick anecdote. We have a client who had a workers' comp case, was receiving temporary benefits, settled the workers' compensation claim, and because of a misjudgment by someone along the way, was never told to notify SSA that the case had settled. So to that extent, while it's not a time limit, it's a matter of some urgency that as soon as the case settles, if your Social Security has been depressed, deal with it. Give Social Security first a copy of the workers' comp settlement agreement and say, hey, look, I settled my comp case. They've prorated what this benefit is worth to me under workers' comp. could you please get my Social Security rate back up to $3,000 a month and stop giving me this particular guy was getting $88 a month? And it was brutal. And he came to our firm with this problem, and we're on, because everything takes forever with Social Security, we're on the edge of having it fixed. But it will be resolved, and he'll have his back money restored. But I would say that if you're dealing with workers' comp and Social Security, time is of the essence in keeping Social Security informed of what's going on when you settle the workers' comp case. Or some cases don't settle with workers' comp, and you have to go, it's called an arbitrator. You have to go to like a hearing officer and have the case decided. Same thing. An order is issued. Make sure that gets to Social Security.
Well, what's your advice, the best advice you have for someone who's on workers' comp right now and they're thinking about, hey, should I apply for SSDI?
Okay, I'm going to wade into some territory in which my workers' comp colleagues might disagree with me. But I tell them all the time, straight out, I look them in the eye and say, could you please have your clients apply for Social Security right away? As soon as there's a serious injury and you know the worker's not going to be going back to work for a year, get that claim on file for a couple of reasons. Number one, these claims take forever. Again, covered in other episodes, but they take forever. So get it going early, get it denied early so we can get on with the appeal. Number one. Number two, if you wait too long, your client's leaving money on the table. You can collect Social Security benefits up to a year prior to the date of application if you were disabled at least 18 months before that date. But sometimes we have clients come to us 4 years later, and we say, why didn't you apply for Social Security years ago? You've lost 2 years of benefits. And their answer almost invariably, Chelsea, is my work comp lawyer told me not to.
And at that point, can they get the last 4 years? No.
They can only get 18 months before the year rather, before the application, assuming they've been disabled at least 18 months. Okay. Now, the comp lawyers, and I love the comp lawyers, and I was married to one, the comp lawyers say, well, Deb, it messes up the Medicare set aside. It messes this up. It delays the payment, whatever. And I always say, nope, I don't believe it. So, yeah, I would say if you potentially have a comp and a Social Security case, get the Social Security case on file immediately. Don't delay.
It's great advice.
Yeah.
Don't wait, guys.
Don't wait.
If you're dealing with both a work injury and a disability claim, you don't have to figure it out on your own. Connect with Deborah at spectorandlens.com for clear, experienced guidance. And be sure, like, subscribe, and leave a review of this episode if you found it helpful. Thanks so much, Deborah.
Thank you, Chelsea. What a pleasure. See you later.
See you soon.
Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.